Another current event which is there in all the newspapers last few days, it's about parliamentary privileges and fundamental rights. What's the balance there? What's the relation? Which one prevails? Which one doesn't? And so on. So let's get the basics here. Parliament at the union level, state legislatures, they have to work independently. They have to work efficiently. They have to work unhindered, and they have to protect their dignity both from outside and from inside, for which they have certain privileges and immunities. What's a privilege? Special right. For example, Constitution says that a member of parliament can speak against a judge, including his personal conduct, when impeachment, that is removal proceedings, are taking place against the honorable judge. Even otherwise, Article 105 says that the freedom of speech and expression of a member of parliament is not limited by reasonable restrictions as you find in Article 19.2, which applies to you and I who are outside the parliament. In other words, they have freedom of speech which is relatively unfettered. A member of parliament cannot be arrested in a civil case while the parliament session is on, 40 days before and 40 days after the session of the parliament, or the proceedings of the committee of the parliament of which the member is a part. So this is an immunity. That was a privilege. Imagine parliamentary proceedings are taking place. Some unparliamentary word is spoken, and the honorable speaker says it is expunged, it is deleted, it cannot be reported by a newspaper or discussed on YouTube or a TV channel. Then that part which has been expunged is dead. If anyone reports, action can be taken. What kind of action? I'll come to that. So these are the privileges, these are the immunities of the parliament for them to work with all the dignity intact. But at the same time, Part 3 of the Constitution, Articles 19 and 21, which are the fundamental rights, they confer on us, respectively, freedom of speech and expression. If I'm a journalist, that's my profession, that again is covered by Article 19(1)(g), and also the liberty, the life, which will come back into discussion a little later. So Article 19, Article 21, these are the fundamental rights. And Article 105 for Parliament, 194 for the state legislatures, these are the privileges, immunities and so on of the Parliament. So can there be a clash between the two? Of course there can be a clash. I will take you back to 2003. In the Hindu newspaper, a very powerful editorial was written against intolerance of the then state government. Then the state government did not like it. The state legislative assembly, and based on what they said, the honorable speaker of the assembly gave an order that whoever wrote the editorial and a few correspondents of the Hindu newspaper are to be arrested and jailed. Then they went underground. Their Article 21 was at stake. Article 21, we all know, says that no person's life or personal liberty can be deprived unless procedure established by law is followed. Not only that, this is 2003. Maneka Gandhi verdict also kicks in. Due process has to be followed. And so they, with the help of Article 226, the writ jurisdiction of the High Court, Article 32, the writ jurisdiction of the Supreme Court, they went for Article 21 of theirs to be protected. And the Honorable Supreme Court said they cannot be arrested because where is the procedure that you are following? Where is the code? You have a civil procedure code, you have a criminal procedure code, you have a bankruptcy code, you have a direct tax code. Like that, where do you have a code of privileges and immunities? You have none. Therefore, you can't touch Article 21, you can't arrest them, and they are free. Now, what's the point here? The point is, quite a few times since 1959, the Searchlight case, there have been cases of tension between parliamentary privileges and fundamental rights. Let me recount all of them for you so that you will have a better, more clear picture. So what was the Searchlight case about? Searchlight case, that is MSM Sharma case, 1959 says, Parliament has its privileges, which have a constitutional basis, Article 105. And the press, the individuals, the journalists, the media, they have their fundamental right, Article 19(1)(a). If there is a clash, it is the parliamentary privilege that prevails. What happened then? You know, like I told you, parliamentary proceedings, a portion of that got expunged, cancelled, nullified, and nobody could report that. Reporting that would constitute a breach of privilege, Article 105, which is also, it has to be followed. So when it got reported, the case went to the Supreme Court when, the legislature wanted to take action. That is when Supreme Court said, see, you got your 19(1)(a), freedom of speech and expression. They got their 105. This is a general right, that is a special right. Both are situated within the Constitution. So whenever the special and the general clash, both having the same constitutional status, it is the special that prevails. It is the special that prevails. And therefore, if the Parliament takes action against Article 19 being exercised for a expunged portion of the parliamentary proceedings, parliamentary action of nullification of Article 19 is correct. Delete it from the newspaper. Say that it is deleted, etc. So that is what they said in MSM Sharma case in 1959, popularly known as the Searchlight case. Then in 1964, another sensational case was there, and that further refined the balance between fundamental rights and the parliamentary privileges. There, the UP Legislative Assembly wanted to arrest a journalist, and the UP High Court stayed it, and there was a clash, and that was not the best of a spectacle. And therefore, the President of India referred the case about the balance between the FRs and the privileges to the Honorable Supreme Court under Article 143, the presidential power to refer a matter to the Supreme Court for its opinion. And there the Supreme Court made a fine difference. Article 19, freedom of speech, situated against Article 105, their privilege to ban certain portion of the parliamentary proceedings, privilege prevails. But it's not the same about Article 21. Article 21 clearly states that unless there is a procedure established by law and compliance with that, Article 21 cannot be restricted. Life and personal liberty cannot be restricted. And therefore, parliamentary privilege can be enforced against 19 because of the same level of constitutionality. Article 21 is protected and it cannot be touched by the enforcement mechanism of the parliamentary privileges. So 21 is protected. Then comes the sensational case of the Hindu, that is N. Ravi versus the Speaker of the Legislative Assembly of Tamil Nadu State. That is in 2003. I already told you about it. A strong, pungent editorial got acted upon, sought to be acted upon, and the Supreme Court came to the rescue of the journalists, saying that where is the procedure established by law. So, and then comes, about 20 years back today, there was a cash for query scam. Some parliament members said, give us cash and we'll pose the question in the parliament. So give us cash for the question we're going to ask in the parliament. And there was a sting operation. and all the members got expelled by the Parliament, and they followed a certain procedure, and the affected members went to the Supreme Court. The Supreme Court said the regulatory power of the Parliament to regulate its proceedings includes the power to expel as well, not only to suspend, admonish, reprimand, and so on, expel as well. But this power has to be exercised constitutionally, not arbitrarily, unfairly, and therefore the judicial review is there to ensure the constitutionality of the exercise of the power of enforcement of the privileges by the Parliament. So that is the case I have already mentioned. That is the case about Rajaram Pal. We'll come to that. That is 2007. Now, so this is the case law about the balance between the two. So what is the outer limit of the privileges and immunities? Are they, to what extent are they limited? To what extent are they unlimited? Basic structure, rule of law is one limitation. Another limitation is 21 requires procedure established by law. Another limitation is that you have to codify for enjoyment of the privileges in a substantive manner. Uncodified privileges run the risk of their enforcement being blocked by the Supreme Court. And further, yes, the members of Parliament can criticize the personal lives of the judges also. That is only when impeachment, removal proceedings are there. Otherwise, they cannot. At any rate, there is judicial review over and above all this. That is called the due process. According to that, the courts will look into the fairness or the arbitrariness of the privileges and their enforcement. This is the outer limit. Now, do you think the balance between FRs and the privileges is correct today? Whether it is correct or not is based on the following. 19 article can be sacrificed at the altar of the parliamentary privileges. 21 cannot be touched. And every other privilege and immunity being enforced against anyone will also require that they follow fair procedure. Tell him why action is sought to be taken against him. Give him a chance to defend himself. Give him adequate time and you should not have any self-interest in enforcing a privilege and limiting the liberty and freedom of anyone who is on the other side. So all these are being observed, but it will be quite welcome if the Parliament codified the privileges. The power to codify is given in Article 105.3, and the code is what? Systematically say what are your privileges, systematically say that what constitutes their breach. Breach is there is a privilege that the member of Parliament cannot be arrested. That is said in law, and if that is broken, that is a breach of privilege, because what is statutorily, constitutionally stated is being broken, and that is a breach. What is contempt of the House? Contempt of House is also breach of privilege, but all breaches of privilege, you breach a privilege, it is a contempt of House. But you say something that doesn't breach a privilege, but it constitutes slandering, scandalizing Parliament, attacking its dignity. So that doesn't constitute breach of privilege, but it constitutes contempt of House. So either way, you defend, you codify the privileges, you say what is a breach, you say what is contempt, and you say what attracts what level of punishment, and spell out all the modalities, the pathways to punishment, etc., and the safeguards, etc. Such a code doesn't exist. Now, there have been conferences of presiding officers in which the Honorable Speaker and the Honorable Chairperson of Rajya Sabha, they have repeatedly promised that we will codify the privileges for greater certainty. Even the press has to know what to say, what not to say. Only then you can have a clear-cut, balanced, fair relation and respect of 19. But the Parliament chose not to codify. Why? You know, once you codify, it becomes a law. Once it is law, under Article 13, no law can restrict fundamental rights. And that is how fundamental rights are kept on a higher pedestal. And both the High Court and the Supreme Court, particularly reach of the Supreme Court, you can reach the Supreme Court instantly, directly. The court can defend your fundamental rights. So codification means legislation. Legislation means making a statutory law, and that cannot run against the fundamental rights. This is the actual reason that Article 13 comes into action. If you codify, you wouldn't like to be pushed back on that. Therefore, you have not enacted a code. But I have heard the Privileges Committee chairperson some years back say that, where are the breaches? How often are the breaches? For the last many years, you have not heard of a single breach. So where is it a priority for us to codify? Therefore, we have chosen not to codify. We respect the press. We coexist with the press. Press is the fourth estate, and that is how the codification has not happened. So this is a story of the privileges, fundamental rights, how they coexist, how they clash, who wins, who loses, and the story of the codification, the case law, etc., etc. And most recently, the Honorable Supreme Court, you have seen it last week in the newspapers, Honorable Supreme Court is seized of the matter. It says the balance between fundamental rights, 1921, and the privileges, essentially 105, this balance is an evolving story. It has not been fully clarified. We still don't know how the balance is structured. And therefore, the Ravi case we began our discussion with, 2003, has been referred to a 7-judge constitution bench that will nail it. Remember, Keshav Singh is an opinion of the Supreme Court expressed on being asked to do so by the Honorable President under Article 143. That has no binding value. It's an opinion. It's an advice. It's been consulted, and therefore it tendered its opinion. So now a 7-judge bench will clarify categorically the relation. But the only point is the case hearings will begin in October, and we really don't know when the verdict will come. Whenever it will come, it will have great value for posterity. Now let us see the basics with the help of infographics. So parliamentary privileges versus fundamental rights. We talked of 105 with the privileges and 194 for the state assemblies. So freedom of speech inside, I told you, relatively unfettered freedom of speech they have. Some fetters will be there. No right is absolute. Even the rights of the parliamentarians within the house. But compared to what you and I have, the restrictions which are reasonable, of course, under Article 19.2, they don't have. So that is unfettered. Control over proceedings, what gets reported upon, published, quoted, will be decided by the Parliament. Anything that has been omitted officially, which is expunged, cannot be reported outside. And if it is, then the court will swing into action and enforce its privileges. So 19.1a, Article 21, we discussed fairly in decent detail. Then, again 105.3, they got the power to codify, by law. By law means codification, but they have chosen not to. Why? Article 13.2 says any law which contravenes the fundamental rights to the extent of contravention is invalid. And that is a powerful protection to fundamental rights. And based on that, the courts have enormous undefined powers. And therefore, Parliament chose not to codify and survive rather than codify and get defeated. That is one criticism, one point of view. Right or wrong, nobody knows. They will lose if they codify constitutional immunity, Article 13, and then massive judicial scrutiny for the reasonableness. That is why codification. I already told you Extremely rare breaches we have. Last time you had heard of a breach was in 2011 or so, when in the Anna agitation, when the iconic police officer Kiran Bedi mocked Parliament and parliamentarians and ministers, she was proceeded against. That was 15 years back. Since then, none. And therefore, the rarity also suggests that you don't take it up as a priority. Next. Next. Contempt. Boundaries. This is contempt. I told you already. Breach of privilege, contempt of house. Breach is specific. Arrest against the constitution. Breach of privilege. He enjoys a privilege, and that privilege has been denied. So it is a breach against what is legally stated. Contempt of house, you say something, a lot of people talk loosely against the parliament. Imagine talking loosely against the parliament in the newspapers or on the TV. That is not stated to be, that's not a breach of privilege. Where is it said that you can talk like this, not like that? But it means you are talking in a derogatory manner towards the parliament. The dignity of the parliament is being downgraded, and that constitutes contempt. You're showing contempt to house. You're not giving it respect. Or a privilege being breached is also contempt, and something unstated being violated, that's contempt, because a contempt is the showing no respect to parliament. That's not stated anywhere you should respect. I don't know what it means to respect. I thought criticizing the parliament is better than not criticizing for the citizen of India. But it's up to the parliament to see whether the criticism is derogatory or respectful, etc. So you got the difference between breach of privilege, which is violation of the stated, contempt of house, violation of the unstated, which is the dignity in general. Boundaries. I already told you there is judicial review, there is Article 21 due process, there is procedure established by law, there is also the basic structure of the constitution. There is Keshav Singh of 1964 where 21 is explicitly protected. They are all the outer limits. And when you codify, you will strictly limit the entire process of enforcement of privileges by spelling out one by one the privileges and then how they are to be protected, how they are not to be violated, what are the consequences of violation, what is the procedure, what is the extent of judicial support available, etc., etc. That is the outer limit. Boundaries. Next, why privileges win over Article 19(1)(a)? I told you 19(1)(a) and 105, both of them are same constitutional status they enjoy. But when there is a general right, the general provision, and there is a special provision, there is a clash between the two, the doctrine of harmonious construction requires that you have both of them prevail, in which case both of them prevail with a certain balance. In this case, the general doctrine is harmonious construction based on the principle of special constitutional law trumping over general constitutional law, in which case 105 is prevalent over 19(1)(a). That's the basis for the prevalence of 105 over 19(1)(a). Special against the general. And both of them have to coexist, surely. Press is the fourth estate. They have to coexist with the legislature, and therefore harmonious construction. And then why it gets defeated against 21? Because 21 clearly states procedure established by law. Menka Gandhi makes it substantive and procedural due process. And so, against the two, how can you coerce? How can you arrest a person? Where is the law? There is no law. It is only a resolution passed by the legislature, and that's not law. That is an occurrence. That's all, an expression of the opinion. and therefore 21 wins over 105. 19 does not, because 21 strictly, categorically, explicitly requires procedure established by law. The case law, I told you MSM Sharma 59, the Searchlight case. Told you Keshav Singh 1964, Rajaram Pal 2007. And then of course, the most current of them all, N. Ravi, the Hindu. N. Ravi and others means some journalists of the newspaper, versus the Speaker Tamil Nadu Legislative Assembly. That is when you had Article 32 invoked in defense of 21, and that is the case being referred to the 7-judge bench, so that the final contours of the relation, the most fair relation, the balanced relation between the two will be established by the Supreme Court. Hearings are going to start in October. This is August, October. And we will know a categorical picture. Until then, we have all these case laws. This is the Hindu newspaper the other day. All of you have seen. Everyone has seen. So that's the discussion about the hottest current event in the constitutional field, which is fundamental rights versus parliamentary privileges. And all this and more you will get in our polity book, which is very comprehensive, detailed, and written for the UPSC examination. Wish you all the best.